Okay, please be seated. I'm going to take the KSA Equities Holdings Inc. case first. We've got folks here, and I see Mr. Waters here. If you want to just come up to the podium, Mr. Waters, and maybe just quickly make your appearance.
Tyson Waters on behalf of the respondent.
Okay, and this is case number GMD 2023-060066. The respondent is KSA Equities Holdings, Inc. It is, let's see, Officer Mitchell, you're going to testify. What we're going to do is he'll present the case, and then if there's any questions or issues, it's a stipulated case, so we should go through it pretty quick. If you raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, so
Yes,
what have we got?
Okay, we do have a stipulation agreement here. My name is Jerry Mitchell, and I've been sworn in. I am a senior site compliance officer for Martin County. The respondent, KSA Equities Holdings Incorporated, is not present, but on behalf of him is,
Press your button.
okay,
I don't know whether that helps or doesn't help, but
we'll see. That make a difference?
nah, maybe not.
Oh. Okay. Anyways, this case concerns the unassigned property located in Stewart, Martin County, Florida. The case was generated by staff after discovering land clearing activity had occurred on the property without the benefit of a permit or a development order. According to the official records of the property appraisers of Martin County, the property owner is KSA Equities Holdings LLC. And that's County Exhibit 1. Aerial view of the subject property is going to be marked as County Exhibit 2. Yeah, this is Exhibit 2, which is showing the location of the property. On May 26, 2023, Principal Planner Sean McCarthy and myself inspected the property. At that time, we observed that understory habitat throughout the property had been cleared. At that time, I photographed the property. The photographs accurately show what I saw then. They're going to be marked as County Exhibits 3 and 4. 3, we're just showing that the understory habitat cleared, and I'm looking west, and you can see US 1 is the road you see in the background there. County Exhibit 4 is clearing 2. You can also, I'm looking to the east here, and you can see the Hope Salerno Rentals properties, which I'm showing here is clearing activity. I'm also showing the brown stumps, which is salt palmettos in their upland habitat.
Okay, go back to Exhibit 2 and just explain where you are.
Okay, we're at US 1, and this is in Salerno. It's south of Salerno Road and north of Cove Road, so we're at the northeast corner of Southeast Federal Highway and Southeast Hydrangea Street.
Okay. All right. Okay, so that's Exhibit 2.
Yeah, and Exhibit 3 is our ground truthing photos, just showing the clearing of the ground understory clearing activity. And 4 is the same as well, and showing the, like I said, the brown stumps is kind of showing the, that was native habitat that was cleared during the clearing activities. County Exhibit 5 is a Google, it's a January 14th, 2023 Google Earth view of the aerial. It's just showing its rendition of the understory cleared on the property. And the blue lines are approximately the property lines on the property.
All right.
Based upon the investigation, I issued a notice of violation to KSA Equities Holdings LLC. And I'll explain the change in ownership as we go through, hopefully. Hopefully. And I also have Tyson Waters here if I need help. But so originally it was under KSC Holdings LLC. And in that violation, I cited section 4.33, preservation of native upland habitat, land development regulations, and section 4.37, land clearing plans and procedures, land development regulations.
Okay.
In the notice of violation, response was given until October 21st, 2023 to comply. Per the compliance requirements, on July 13th, 2023, the required land clearing permit application was submitted. Subsequently, on December 4th, 2023, the required PAMP application was submitted by the respondent. However, both applications were incomplete because they required additional information to be submitted for staff to complete a full review. Staff had learned that the property is under contract for sale. Attorney Tom Sawyer from Gunster Law Firm represents the buyer in this case. The buyer's intention is to develop the property. Therefore, on June 12, 2024, staff met with Attorney Tyson Waters and Attorney Tom Sawyer to discuss the outstanding compliance requirements for the property, which is the need to obtain approvals for the land clearing permit and also the PAMP application. With the outstanding compliance requirements and with the pending potential sale of the property, it was agreed to enter into a stipulation agreement with the respondent. Based on this agreement, I did hand deliver a notice of hearing to Mr. Waters for the July 17, 2024 hearing. During the meeting, it was brought to staff's attention that the title of the property had recently changed from KSA Equities Holdings LLC to KSA Equities Holdings Incorporated. This was in order to correct errors found in the original deed. The corrective quitclaim deed representing the changes is marked as County's Exhibit 7, and I only put the first page in there for record. I can enlarge that if you need me to. So in essence, basically it went from KSA Equity Holdings LLC to KSA Equity Holdings Incorporated.
Okay.
I completed an affidavit, let's see. Okay. That was Exhibit 7, the deed, okay, number 8. And I updated a notice of hearing with the corrected ownership information and emailed a copy to Mr. Waters. The notice of hearing issued for the July 17, 2024 hearing is marked as County Exhibit 8, and it has the corrected information on it. Also, the legal description had been updated as well.
All right, what's the change in the legal? Maybe
I have the whole entire deed here, and I think either maybe Tyson Waters or Attorney Tyson Waters or Mr. Sawyer could help us with this if need be.
That's fine. Go ahead. Okay, so you've got exhibits 1 through 9. Then
Yeah, yeah. Exhibit 9 is just showing I did do a hand delivery as per statute.
Okay.
And that's kind of, so we did enter into a stipulation agreement. I requested all the exhibits be received into evidence, and based upon the testimony and evidence, I request that the respondent come in compliance with the cited code by April 30th, 2025. And if compliance is not achieved by then, to pay a fine amount of $100 per day per violation thereafter. We have, like I said, entered into a stipulation agreement, and I have received the magistrate administrative costs of $575 enforcing this matter.
Okay.
And this
All right.
concludes my testimony this time.
All right, good. Mr. Waters, any objection to my accepting in evidence exhibits 1 through 9 in this case? All right, so without objection, it's so ordered. And
Pardon me? I knew you were going to.
let me just ask, first off, are the principles of the first, whatever it was, KSA Equities Florida LLC and KSA Equities Holdings Inc., are they the same folks?
So what happened was there was a deed done back in, I think, 2022 that conveyed the property to or attempted to convey the property to KSA Equities Holdings LLC, but that's not an entity. And so the corrective deed was to convey it to the correct entity of as originally intended.
Okay, all right, all right. All right, so, and legal description, what's going on there?
Again, with those, what happened in 2022 was this overall entity, KSA Equities, kind of took ownership of this entire tract of land, including the area that is just to the left on the screen.
Let's look at,
So I think his Exhibit 2 is the best.
look at Exhibit 2.
So that kind of whole tract of land, both what's outlined in blue as well as the land just to the, I guess it'd be to the north, but on the
yes.
screen to
Okay.
the left. All owned by the same entity, conveyed, and as part of that conveyance, it was split into two. Well, there was an error in the deeds that split it, both with the name of the entities that received it, as well as the legal descriptions. So that kind of was of record for quite a while, until both with this violation and also with the property to the north recently obtained site plan approval. And as part of that process is when all of these errors were discovered.
Okay.
So since then, we've been correcting all of these deeds. So that was the change in the legal description. Essentially, it just shifted the property a little bit to the south. So the legal description that's now part of the stipulation is the correct legal description for this subject property. The clearing, what happened with the clearing was the then owner was approached by the sheriff's department one night to say that there's a homeless population community on the site, and was requested to clean up the property. And so with that, he cleared up the underbrush, which without the proper approvals and permits. So that's where kind of we came into this situation. So it was on the entire parcel as part of, similar to what we're asking to do with this violation. The violation on the northern side was cured as part of the site plan approval process, which required a PAMP. So what the stipulation does, it sets a hard deadline, but the idea is as we proceed, or the contract purchaser proceeds with the site plan, that's going to include a PAMP. However, if for any reason that site plan does not proceed, then we're still obligated to do an independent PAMP
Okay,
to ensure compliance either way by that agreed upon date.
all right. So, and the STIP requires you to obtain an approved PAMP by April 30th, 2025.
Which we anticipate is the process ideally to get that site plan approval, but if there's any hiccups, the county's assured that they're going to get the PAMP and the end result that they expect one way or the other.
Okay. And do you have Mr. Collette here?
I do not know, sir.
Okay. All right.
He came to my office yesterday and signed the stipulation.
All right. And signed it in front of you?
I signed it in front of my assistant, but I've been in constant communication with him. And he was at the meeting on June, whatever it was.
June 12th,
He's been
I
an
believe it
active
was.
participant in this.
All right.
He is the principal owner of KSA Equities Holdings, Inc.
All right.
And I am his rep, I do represent the company, and I'm here on the company's behalf.
Okay. All right. Good. Well, based upon the evidence in your testimony and your representations, I'm certainly in agreement with the stipulation, and I will enter the agreed final order, which requires your client to obtain an approved after-the-fact land clearing permit and an approved PAMP by April 30th, 2025. And note for the record that $575 in administrative costs have been paid to the county, and that if your client fails to comply with the stipulation and agreed final order, it will mean a fine in the amount of $100 per violation per day. Okay. All right. Good. Then it is so ordered. Right, and we'll get a copy of that out to you.
Thank you very much.
Okay, very good.
I will,
Thank you. Yes, you can take that. Yep.
I appreciate it, thank you.
All right. Okay, let's see. Second case that we're going to take is the Posner case. It's ENF 2024050411. Stephen Andrew Posner is the respondent, and it's a violation case. Mr. Posner, is that you?
Yes, sir.
Okay. So I'll swear you in after we hear from the county. It's a violation case, so it's up to them to make their case. And after which then we'll go from there. And matter of fact, you can both just raise your right hands if you will. Do you swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
I affirm.
All right, so we're going to hear from Ms. Espiat first, and then we'll go forward. Go ahead. Whenever you're ready.
My name is Maria Espiat, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondent, Stephen Andrew Posner, is present. This case concerns a property at 58 Northeast 16th Terrace in Stuart, Florida, in Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Stephen Andrew Posner. A copy of the property appraiser's record of ownership is County's Exhibit 1. On May 7th, 2024, I inspected the property. At that time, I observed trash and tents on the property. At that time, I photographed the property. The photograph accurately shows what I saw then and is marked as County's Exhibits 2 and 3. Let me zoom in a little bit. These are the tents. There's a small brick right there. Exhibit number 3 has some wood leaning. And here's another angle of the tents. And there's some tree debris here in the front. Based upon the investigation, I issued a notice of violation to the owner on May 16, 2024, marked as County's Exhibit 4. In the notice, I cited the following Martin County Code violation: Section 67.201.b, trash, nuisance declared trash, etc., General Ordinances, Martin County Code, and Section 3.11, permitted uses, land development regulations, Martin County Code. In the notice of violation, the respondent was given until May 30th, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. On May 28th, 2024, I received an email from the owner who wanted to know information about the violation. The email is County's Exhibit 5. It shows his email and my response. Oh, sorry.
Okay, great, thank you.
I did a follow-up inspection on June 5th, 2024, and found more trash on the property, and tents remained on the property as well. The follow-up photos are marked as County's Exhibits 6 through 9. Number 6, you can see the tents here, still some tree debris, the wood. Number 7 is the other side of the property, and this is all trash. Number 8, it's a different angle, more trash scattered. And number 9 is a map. So where the tents are is on this side right here. And this is all in red is the whole entire parcel. And this side would be where I did my follow-up of these photos. After the follow-up inspection, I emailed the owner but did not receive any reply. The follow-up email is County's Exhibit 10.
Okay,
Compliance was not achieved, and a notice of hearing was issued by certified mail and regular mail on June 17, 2024, and is marked as County's Exhibit 11. The return receipt was not returned, therefore, on June 27, 2024, I posted the property in the Martin County Administrative Building. The affidavit of posting is marked as County's Exhibit 12. No more contact was received from the property owner. Therefore, I went again to the property on July 16, 2024, and saw the cited violations had not been corrected. At the time I photographed the property, the photographs accurately show what I saw then and are marked as County's Exhibits 13 through 18. We still have tree debris here, some more trash, and a bit more on this side as well. Number 14, same trash, and now there's wood, and it appears, I don't know what this is. 15 is another angle, more trash, some here, some more wood on the floor. 16th is where the tents were, so the tents are removed, and now we have all of this. 17, the tree debris. And 18 is just a different angle. And here's some containers, plastic containers. I request that all of the county's exhibits be received into evidence. Based upon the testimony and evidence, I request that the respondent, Stephen Andrew Posner, be ordered to comply with the cited provisions of the Martin County Code by August 30th, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 per violation for every day the violations continue thereafter. The county has incurred a cost in the amount of $575 conducting this investigation and requests that the county be reimbursed this amount at the conclusion of today's hearing.
Okay, sir, if you will, give us your full name and your address.
Well, my name is Stephen Pausner, and my address actually is part of the thing that I'd like to talk about, because on my deed, I believe it says 48 Northeast 16th Terrace, and also the mailbox situation has evolved over the past year. I'm a first-time homeowner, a new homeowner. I bought the place and moved in basically in September of 2023. I think there's also that 58 thing, and there's also an issue of the homestead. I went to the homestead office, and at the time when I bought my property, there was a tenant living there on month to month
Okay,
that I had to be able to.
let me just stop you for a second. The property that we're talking about, let's call it the subject property, is that the property that you own?
Yes,
Okay, and you're saying that there
the one in the pictures is correct.
there
It's
could be
my
a
property.
discrepancy with the address. Is that,
The address situation is very odd, but the properties that she's taken, that is my property
okay,
in the pictures.
all right. And I unfortunately, I can't really resolve your addressing issue. That may be between you and the property appraiser and the post office and,
There is an issue that this lady brought up about the zoning, single-family housing, that I'm zoned for, to return it back to a single-family housing. The entire square, it's about 100 meters, 100 feet by 100 feet. That belongs to me. There's no longer any tenant there. It's just me. I own it. I live there. The entire place is mine. I was considering, I'm not sure, well, I guess at this point, I would go to the homestead office and make it 100%. But even still, with what she's saying, it's still at least 3/4 already single-family. That's one question. Another question is,
Your Honor, if I could just clear that up, that had to do with the tent violation as far as people possibly living in the tents. It has nothing to do with it, and that's moot now because that violation is no longer exist.
okay. I look at Exhibit 9, if you can pull that up.
sir, if I could add one thing about the tents, they were entirely for storage only. There was boxes in there and stuff like that.
Yeah, and I think.
No one was living in there.
That's what-
I live in the trailer that's marked by the number 15 there. But my intention is to build a home in the middle and including the trailer and the guest house and the shed and stuff like that. So I think permitting is the question, and debris and trash is the question, and the metal plates and building materials
All right,
are
but-
the question that I have.
Let me just make a point and a question, I guess, to the county. is the permitted use violation that was charged, 3.11, is that still an issue in this
It's
case?
resolved as of yesterday.
Okay, so that's, I'm going to take that off the case completely.
I still have a question about that, sir. What if I did want to have tents up that I wanted to be in overnight on my own property?
I don't think,
Or what if I wanted to have other people on my property in tents? And she takes a picture?
well, if you're renting the tents out, if you've got multifamily use of it, then you can't do that,
But
but
then we'd be back here talking about it. Is that what you're saying?
that's.
There would be an issue, she would take a picture, and then we'd come back and talk about it?
You know, that's pretty remote, and
It's a possibility.
of course, it's a possibility, anything's a possibility, but I wouldn't worry about that. Let's just address what we
My
have in front of
intention,
us.
my
and that's
intention
trash.
was for storage only.
Okay, so
That
we
should
got
be very
trash on
clear.
the property that I see in those photos. And let me just ask you, there are 18 bits of evidence that the county has presented. Do you have any legal objection to any of those?
I am not understanding exactly what the issues are, is why I'm here.
Okey doke. Well,
Debris and trash, I guess, is the next part. If the permitting is clear, and then, so the tents are gone right now, but my intention is to build storage sheds, a house, a garage, a home, a castle.
okay, so you.
So I
filed
have
for
building
permits?
material, and I have formations with the cuttings of my trees.
Hang on, stop talking for a
Yes,
second. When you're ready to do all of that, you're going to file for permits with the county. You're going to have drawings that show exactly what it is you're going to do. And you'll deal with the building department over those permits. Don't project a situation that hasn't occurred yet. All we're looking at today is trash on the site. And they're, based on the evidence, and I'm going to, unless you've got some legal objection, I'm going to enter into evidence the exhibits 1 through 18 in this case. And
There are pictures that she's taken of my house. I agree that that is true. I disagree on what is considered trash and debris.
yes, and I understand that, but that's not a legal objection to those photos or the rest of the evidence. So I'm going to say without objection, I'm going to enter into evidence exhibits 1 through 18 in this case.
Yes, sir.
Looking at those, I see trash and debris strewn around the property. That's what we're down to. It's one issue, and basically, I think I've seen enough to tell you, you're in violation, you're going to need to clean it up. It's not a big deal, but it's something that you need to take care of as the property owner, because the county code doesn't allow it to look the way it looks today. So the county has asked for compliance on or before August 30th. Any reason you can't get it cleaned up by that time?
Sir, my next question would be, what are my artistic rights to build as I go?
You know-
And to have the building material available
Just-
to explore and to play?
Answer my question. Is there any reason you can't clean up the property by August 30th?
At this time, I'm still not understanding what I'm allowed to do and what I'm not allowed to do.
Okay, and you'll work with the code enforcement department, and they're pretty good at knowing what the codes require and don't require. Ms. Espiat has been at this a while. I'm sure she'll be happy to come out and walk the property with you and tell you what you can and can't do. Okay? But, and even if you don't understand at this moment what the violation is, I'm looking at the evidence, and I can tell you, based upon the evidence, that a violation does exist on your property because of the trash and debris and things that are strewn around it. And so it's a simple fix. You just need to go clean it up. And, all right. I think I've heard enough. I'm going to find that based upon the evidence, your testimony, sir, and Ms. Espiat's, that a violation of 67.201B trash does exist on the property. I'm going to order you to comply by no later than August 30th, 2024, failing which a fine in the amount of $100 per day will accrue. And I am going to award costs in the amount of $575 to be paid to the county at the conclusion of the hearing. So that's my ruling, and I think you just need to
Sir, I'd
clean up
like
your
to
property.
ask that a third party, another agent be assigned to objectively, with a new set of eyes, take a look. I would be willing to work with someone else. Someone who is not the initial investigator.
And I mean, you're welcome to talk to the county about that, but I'm not going to, I don't assign code officers. All I'm saying is I don't see a reason for that, but, you know, that's just me. You can take that up with the county code enforcement office. Okay?
Sir, I have $300 in cash today. That's,
Okay. I'm sure the county will take it on account. But the ruling stands at $575. Good luck. I hope you get the property cleaned up by that time.
is there an appeal? I noticed there is an appeal process, but I'd
Yes.
like to ask about it
There is.
specifically because
and,
of the fine.
The county code enforcement office can tell you about that as well. It is to the circuit court. And you're welcome to take an appeal of my decision.
How would I go? I thought I was talking to the county and the code enforcement magistrate. I'm confused here. You're talking about talking to the county. I'm talking to you. You seem to be the chair of this meeting.
No, this is not a meeting. It is a hearing. I am a magistrate. I just ruled in your case. I don't have really anything to do with the county staff. They make appearances before me just the way you make an appearance. I'm independent, and I don't, work for the county in that regard. I mean, it's a scenario where you have as much right as they have. And so I've heard the case, I've heard their testimony and evidence, I've heard your testimony, and I've ruled on the case. Okay, and you'll get a copy of this order. And if it occurs to you after reading it and thinking about the hearing and this process that you want to take an appeal, you're welcome to do that. You have to do it within 30 days. So make sure you do that. Again, I don't represent you, so I can't tell you how to do it. But if you find an attorney who is familiar with the process, they can take the appeal to the circuit court. Okay? All right. Okay. Now, your alternate is to just go pick up the trash on the property.
The question would be, where would it go? That would be my big question.
Well, where does all trash go?
I don't consider it trash.
Okay.
It may be debris, but it's building material for me.
Then if it's properly stored, and you again, take that up with the county. They'll guide you on that process.
I had the tents as storage, sir.
Yeah, no, that's not acceptable storage, so.
Okay.
Okay, all right. Thank you. Good luck.
She'll meet you back there.
You gotta give him a copy of the. Yeah, she's gonna give you a copy.
Probably your
All right.
would be next, right?
Do we have the Schatz case? Is that gonna,
He paid, okay. We've removed that one. He came into compliance.
okay, came into compliance, good. Okay, that's great. I noticed, looking at the docket, that there were, looks like 4 cases that were in compliance? 3 cases, I guess. Which is great. That's
We're trying.
good work. All right, so the next case is the Byrne case. Christopher and Julie Byrne are the respondents. It's ENF 2024-040915. And Officer Ambrisetti, you're going to testify if you raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right,
Your Honor, this is a stipulated agreement.
okay. All right, good. We can take that and show it as a stipulation.
My name is Charles Ambrisetti, and I've been sworn in. I am a code compliance investigator for Martin County. The respondents, Christopher Burney and Julie Burney, are not present. This case concerns the property at 861 Northeast Industrial Boulevard, Unit 19, Jensen Beach, Florida, 34957. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owners are Christopher Burney and Julie Burney. A copy of the property appraiser's record of ownership is County's Exhibit 1.
Okay,
On April 29, 2024, an expired permit letter was emailed to Christopher Burney. A copy of that letter is marked as County's Exhibit 2. Based upon the investigation, I issued a notice of violation to Christopher Burney and Julie Burney on May 2nd, 2024, marked as County's Exhibit 3. In the notice, I cited the following Martin County Code violation, Section 105.1 Florida Building Code, permits when required, incorporated by Section 21.1 General Ordinances, Martin County Code for expired storage loft permit. In the notice of violation, the respondents were given until May 31st, 2024 to correct the violation and were informed of the need to contact Martin County Code Enforcement upon doing so. On May 31st, 2024, I checked the permit status and the permit remained expired. Since compliance was not achieved, a notice of hearing was issued by certified mail on June 4th, 2024 and is marked as County's Exhibit 4.
okay, let me just stop you for a second. I'm trying to understand exactly what the issue was. It looks like they had applied for a loft of some sort in a, is it like a work-live unit, or is it
What it is, Your Honor, is a storage unit where people store their vehicles.
Okay. All right. Okay, so that, I see in Exhibit 4, Unit 19, Jensen Beach Auto Vault Condominium Association. So
Yes, sir.
it's, okay, so it's that type of building, and what, they had applied to build a loft above, like where you might pull in vehicles, is that?
It's a multi-level storage building,
Okay,
and their permit for Unit 19 got to the end and failed the final inspection.
okay, got it. All right, go ahead. I'm up with you on Exhibit 4.
On June 26, 2024, I conducted a follow-up investigation but due to the property being gated, I could not access the unit. This is marked as County's Exhibit 5. Here, Your Honor, you can see
Yeah,
how it,
yeah, that actually kind of explains a bit to me. Good, thank you.
yes, sir. However, a search of the inspection log showed a failing final inspection on April 23rd, 2024, and a screenshot of that inspection log is marked as County's Exhibit 6. And you could see here, it failed the final structural for a handrail issue, which left the final structural now pending. Oops. The return receipt was not received, so on June 27, 2024, I posted the property. A photo of the posting and the affidavit of posting are marked as County's Exhibits 7 and 8. My affidavit of posting, photo of the posting outside the gate of the property.
Okay.
I have spoken to the property owner and explained what he needed to do to come into compliance. Therefore, I checked the permit status again on July 16th, 2024, and saw that the cited violation had not been corrected. A screenshot of that permit status is marked as Exhibit 9. However, on July 16, 2024, the owners of the property, Christopher Burney and Julie Burney, entered into a stipulation agreement with the county and agreed to receive a passing inspection by the Martin County Building Department on or before November 1st, 2024. And if not in compliance by then, the owners will be required to pay a fine in the amount of $100 a day thereafter for each and every day of non-compliance. The administrative cost of $350 has been paid by the owners. And with that, I request that all the county's exhibits be received into evidence.
Okay. All right, so let's see, without objection, I'll accept into evidence the county's exhibits 1 through 9 in this case. And I'm now looking at the stipulation and see that it tracks your testimony and that $350 in administrative costs have been paid to the county.
Yes, sir.
And that Christopher Burney and Julie Burney have signed on behalf of themselves and that you have signed on behalf of the county.
Yes, sir.
And with that, seems pretty simple, pretty clear. I'm going to go ahead and execute the agreed order in this case. Okay,
Thank you, Your Honor.
thank you. Let's see, that was by November 1st. Okay. All right, next case. Also a stipulation, Officer Counselor, you're going to testify. This is the Thomas Hunter Price case. Formerly known as, I'm going to take a guess here, Francel Eggett Dame Thays. Is that right? And Francel Eggett Price.
I think it's they, Francile, Edget Dame, as per the deed, and then she added Price, because they are married.
Okay, all right. So this is husband and wife?
Correct.
Okay. All right, so it's case number ENF 2024-010022, and this is also a stipulation.
Correct.
And if you raise your right hand, do you swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, whenever you're ready.
My name is Chris Counselor. I've been sworn in. I am the code compliance investigator for Martin County. The respondents, Thomas Hunter Price and Thay Francile Edget Price, are not present. This case concerns the property at 5140 Southeast Front Avenue, Stuart, Florida, located within Martin County. This case was not generated from an anonymous complaint. This is, the owners have signed and agreed to a stipulation agreement. According to the official records, the property appraiser of Martin County, the property owners are Thomas Hunter Price, Dave Francile Edgett Price. A copy of the property appraiser's record of ownership is County's Exhibit 1.
Okay.
On January 23rd, 2024, I inspected the property for an expired permit application, BLD 2023-061-753 for a fence. At the time, I observed that the work on the fence had been done without an issued permit, and a new slab had been installed also without a permit. At the time I photographed the property, the photographs accurately show what I saw then, and I marked as County Exhibits 2, 3, 4, and 5 with the expired permit application letter as County Exhibit 2. So Exhibit 2, this is what initiated the case, was an application showing expired. Exhibit 3 is my visit to the property. The new fence section is to the right, and then this new slab here, right in front of the trash cans, was also installed.
Oh, okay. Let me just ask a question, and maybe this is for everybody's edification. When the building department issues one of these letters that says an application for a permit for proposed work has deemed to have been abandoned, 180 days has gone by and no inspections were triggered, does that automatically come to code enforcement? Is that how that works?
Yes, it does.
Okay. So that's how that case basically starts internally from the building department to code enforcement. Okay, got it. And I actually, it's funny, I've been doing this a long time, but I never really knew how that process worked. All right, go ahead. I'm sorry, I interrupted you.
Very good.
We're up to exhibit.
The Exhibit
Or-
3 is just the front of the property showing the new fence section and the slab. Exhibit 4, just another view of the fence section that was installed. And Exhibit 5, just an angle shot showing the new slab that was also poured.
Okay,
Based upon the investigation, I issued a notice of violation to Thomas Hunter Price, Dave Francile Edgett Price on February 7th, 2024, marked as County Exhibit 6. That's my notice of violation. In the notice, I cited the following Martin County Code violations. Section 105, Florida Building Code as adopted by Section 21.1 General Ordinances, to obtain a permit for the slab and the fence, or to remove both. In the notice of violation, the respondent was given until March 7th, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on June 24th, 2024, and is marked as County Exhibit 7. The return receipt was not received, so on July 3rd, 2024, I posted the property. A photo of the posting and the affidavit of posting are marked as County Exhibits 8 and 9. 8's my posting. 9's my affidavit of posting.
okay,
On the day of the posting, I met with the owner, Mr. Price, and he agreed to a stipulation agreement. Basically, he had become confused with the permitting process and needed some more time, so I offered a stipulation agreement. So on July 8th, 2024, the owner signed and paid the required $350 for the stipulation agreement. I requested all the county's exhibits be received into evidence. Based upon the testimony and the evidence, I request that the respondents Thomas Hunter Price, Dave Francile Edgett Price be ordered to comply with the cited provisions of the stipulation agreement by October 1st, 2024. And if not in compliance by then, be required to pay a fine in the amount of $100 per day until the violations are corrected. That concludes my testimony.
all right. Okay, so without objection, I'll accept into evidence the county's exhibits 1 through 9 in this case. And based upon the evidence and the stipulation in front of me, find that stipulation requires compliance on or before October 1st, 2024, failing which you find in the amount of $100 per day will accrue. And note that respondent has paid $350 in administrative costs to the county. The stipulation is signed by Thomas Hunter Price and Thais Francile Edgett Dame Price on behalf of themselves and Officer Counselor on behalf of the county. So I'm going to find that it's appropriate to enter the agreed order in this case. And note we've got a little bit of a formatting problem. I'm just going to put agreed order on the top of the page that I'm going to sign.
Okay. Thank you.
You don't need to redo this or... It's fine just the way it is. Okay.
All right,
Very
thank you.
good. Thank you. All right, let's see. Officer Marcos. All right, we've got case number ENF 2024-040295. And the respondent is Adelia Benez. Yep. Adelia Benez. And Officer Marcos, if you raise your right hand, do you swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, whenever you're ready.
My name is Frank Marcos, and I've been sworn in. I'm a code compliance investigator for Martin County. The respondent, Adelia Benez, is not present. This case concerns the property at 1311 Southwest Sunshine Street, Stuart, Florida 34997 in Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Adelia Benez. A copy of the property appraiser's records of ownership is County's Exhibit 1.
Okay.
On April 9th, 2024, I inspected the property. At the time, I observed an inoperable landscaping trailer with the tires sunken into the ground. At that time, I photographed the property. The photographs show what I saw then and is marked as County's Exhibit 2 and 3.
Thank you.
Based upon the investigation, I issued a notice of violation to Adelia Benez on April 19, 2024, and is marked as County's Exhibit 4.
Okay.
In the notice, I cited the following Martin County Code violation. Section 91.34.a, General Inoperable Vehicles, General Ordinances, Martin County. In the notice of violation, the respondent was given until June 3rd, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on June 6, 2024, and is marked as County's Exhibit 5.
All right.
The return receipt was not received, and the property was posted. The posting and photograph are marked as County's Exhibit 6 and 7.
Okay.
No call or letter from the property owner was received within the time allowed. Therefore, I went to the property again on July 16th, 2024, and saw that the cited violation had not been corrected. At that time, I photographed the property. The photograph shows what I saw then and is marked as County's Exhibit 8.
Still there. Thank you.
I request that all the county's exhibits be received into evidence. Based upon the testimony and evidence, I request that the respondent, Benez Adelia, be ordered to comply with the cited provisions of the Martin County Code by August 31st, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day that the violation continues thereafter. The county has incurred a cost of in the amount of $575 conducting this investigation and request that the county be reimbursed this amount at the conclusion of today's hearings. This concludes my testimony.
Okay. I think I heard you ask for August 31st.
Yeah.
The recommended order says August 30th.
That's fine.
I'm inclined to go with the 31st. It's the end of the month, and so I'm going to interlineate the order,
It's Your Honor, it's a weekend. We usually end them up on the last business day of the
which
month,
is
the 30th.
it is the 30th.
The 30th's a Friday. The 31st is the last day, but it's a Saturday.
Okay.
So we generally make the orders run
All
till
right.
the last business day of the month.
Yeah, because otherwise it carries over to September. All right, so anybody here on behalf of Adelia Benez? Seeing no one, without objection, I'll accept into evidence the county's exhibits 1 through 8 in the case. Based upon that evidence and your testimony, Officer Marcos, I'm going to find that violation as charged does exist on the property and order compliance on or before August 30th, 2024, failing which you find in the amount of $100 per day will accrue. And I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing. And it is so ordered.
Thank you, Your Honor.
Thank you. Okay, let's see. All right, so Ms. Espiat, you're back. Okay, this is the Ross or Rossi case, ENF 2024-040239-01. Naida Rossi as the respondent. Whenever you're ready. You've been sworn in.
Yes. My name is Maria Espea, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondent, Nadie M. Rose, is not present. This case concerns a property at 4110 Northwest Cinnamon Circle in Jensen Beach, Florida, and Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner is Nadie M. Rose. A copy of the property appraiser's record of ownership is County's Exhibit 1. On April 16, 2024, I inspected the property because of a tenant complaint. I observed a broken AC and an exterior damage to the property. At that time, I photographed the property. The photographs accurately show what I saw then, and they're marked as County's Exhibits 2 through 6. 2 is a picture of the thermostat that I did check the AC. 4, some exterior damage to the fascia. 4, more exterior damage. This is the other side of the same area where there's exterior damage. Number 6, there's some more on this side. Based upon the investigation, I issued a notice of violation to the owner on April 19, 2024, marked as County's Exhibit Number 7. In the notice, I cited the following Martin County Code violations: Section 21.110, General Exterior Structure, General Ordinances, Martin County Code, and Section 21.212, Heat Supply, General Ordinances, Martin County Code. In the notice of violation, the respondent was given until May 20th, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. On May 1st, 2024, I received an email from the tenant stating the AC unit was repaired. The email is marked as County's Exhibit Number 8.
Okay. I'm looking at Exhibit 7 and the section that's cited, 21.212, talks about a heat supply to maintain a temperature of not less than 68 degrees Fahrenheit, which is interesting in the context of all the heat that we've endured for the last couple of months. But I do get it. That's kind of a carryover from old Florida, where you still had to have minimum amounts of heat, but we didn't really require AC. However, in this case, the whole unit is broken,
Correct.
so, or at that time was not working. So, okay, but that's cleared.
Yes, according to the email from the tenant, it has been cleared, and they did have a permit for it.
Okay,
However, the exterior violation remained, therefore I issued a notice of hearing by certified mail and regular mail on June 17, 2024, marked as County's Exhibit Number 9. The return receipt was not returned, so on June 27, 2024, I posted the property and the Martin County Administrative Building. The affidavit of posting is marked as County's Exhibit 10. No call or letter from the property owner or the tenant was received within the time allowed. Therefore, I went back to the property again on July 16, 2024, and saw the cited violations had not been corrected. At that time, I photographed the property. The photographs accurately show what I saw then, and they're marked as County's Exhibits 11 through 13, and the permit history is 14.
and what does the permit history show?
The permit history is number 14, shows that no permits have been applied for to do the exterior work. And Exhibit 11 shows that the exterior is still damaged. That's the top of there. The fascia is still damaged. And 13 is the whole area, some here and behind here as well.
Okay, yep, I see it.
I request that all of the county's exhibits be received into evidence. Based upon the testimony and evidence, I request that the owner be ordered to comply with the cited provisions of the Martin County Code by August 30th, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violations continue thereafter. The county has incurred a cost in the amount of $575 conducting this investigation and requests that the county be reimbursed this amount at the conclusion of today's hearing.
Okay, anybody here on behalf of Naida Rossi? Seeing no one, without objection, I'll accept into evidence the county's exhibits 1 through 14 in this case. Based upon that evidence and your testimony, I'll find that a violation of Section 21.110 of the county code does exist on the property. In order compliance, owner before August 30th, 2024, failing which a fine in the amount of $100 per day will accrue. I'll further award costs in the amount of $575 to be paid to the county at the conclusion of this hearing.
Thank you.
So ordered. Okay. All right, moving right along. Officer Bush.
Sir.
I think you've got a few cases. This is the McBride, Anthony W. McBride case. It's ENF 2024-020090-01. Anthony W. McBride. And if you'll raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So
I do, sir.
okay. Whenever you're ready.
My name is Tamika Bush, and I have been sworn in. I'm a code compliance investigator for Martin County. The respondent, Anthony W. McBride, is not present at this time. However, he did show up, but had to leave. He understands the violations, though.
Okay.
This case concerns the property at 13580 Southeast Powerline Avenue in Hope Sound, Florida, 33455 in Martin County, Florida. This case was not generated from an anonymous complaint. And according to the official records of the property appraisal of Martin County, the property owner is Anthony W. McBride.
All right.
A copy of the property appraiser's record of ownership is County's Exhibit 1. On February 14, 2024, I inspected the property, and at that time, I observed garbage, trash, and debris and/or junk and weeds overgrowth. I spoke with a male named Mr. Tony, who stated that he was the property owner, and I explained the violations. At that time, I photographed the property. The photograph accurately shows what I saw then, and it's marked as county's exhibits 2 through 4. I'm sorry, 2 through 5.
Okay, tell me what we're looking at here.
So in this particular photograph, we're looking at some,
Number 2.
yes, sir. It's an accumulation of different types of storage, should I say. Some is trash, some is just furnitures. The garbage cans in this particular photo kind of buries off some of it, but the next photo will show you the remaining violations. As I zoom in,
3.
for Exhibit 3, you'll kind of see it again here. There are a few clearer photos coming up too.
What do I see in 4? Anything?
Well, in 4 is just the vehicles. Initially, the complaint was for an RV with possible persons living inside of it. The owner has since removed the RV. He stated that no one was living in it at the time. I still photographed it from the roadway, and he said that he'll just have it removed. And in photos to come, you'll see that it had been removed, so it didn't remain as a violation.
And then Exhibit 5.
Is again, I believe this is like a trolley or something for moving. Some other items, unidentifiable. There is also like wood and other things that are stored out.
All right.
Based upon the investigation, I issued a notice of violation to Mr. Anthony W. McBride on April 11, 2024, marked as County's Exhibit 6. And the notice, I cited the following Martin County Code violations: Section 67.201B for trash nuisance declared, General Ordinances of Martin County Code, Section 67.201, weeds nuisance declared, undergrowth General Ordinances of Martin County Code. And in the notice of violation, the respondent was given until May 1st, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved and a notice of hearing was issued by certified mail on June 11, 2024, and it's marked as County's Exhibit 7. The return receipt was received, the property and county was not received, and the property and county administration building was posted on July 1st, 2024, and an affidavit of posting is marked as County's Exhibit 8. At that time, there had been no additional calls or letter from the property owner. I went to the property again on July 16th, 2024, and saw that the cited violations had not been corrected. While the lawn had been mowed, which that violation no longer exists, you'll see the open storage again.
All right.
So in this particular vehicle,
Violation of 67201A has been resolved, is that correct?
yes, sir.
Okay, so I'm going to take that off of the recommended order.
Yes, sir.
Okay. All right, go ahead, I'm sorry.
And in this photo, there were just vehicles added, but they were all operable. Just a little bit more items were added out.
Okay.
Says, I believe in this photo, you can pretty much see clearer the wood items and
That's a-
pallets and things that were in the previous photos.
Okay.
There's a chair, a desk, and some other items there.
Okay, that's both Exhibits 11 and 12 show that. Okay, good.
At the time I photographed the property, those photographs, which were Exhibits 9 through 12, at this time I am requesting that all of the county's exhibits be received into evidence, and based upon the testimony and evidence, I request that the respondent, Mr. Anthony W. McBride, be ordered to comply with the cited provisions of the Martin County Code by August 30th, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. The county has incurred a cost of $575 conducting this investigation and requests that the county be reimbursed this amount at the conclusion of today's hearing.
Okay, and you say that Mr. McBride did actually,
Yes, sir, he was here.
what was your conversation with him?
Our conversation was regarding the violations. I did explain to him that he may have contacted me prior to, so that I could have maybe pointed out. He said that he would bring in items from the back to the front, and that he would clear all those items out and call for the reinspection. I did explain that the county was asking for 30 days to comply. He indicated that he should have it done by the end of the week.
Okay,
He did have some concerns for the $575, and that he would contact our supervisor regarding maybe a payment plan or some type of a way of making those payments.
okay. I know that at other times, officers have actually entered into a stipulation on the floor. So you actually can do that if you think that that's helpful. However, the problem with that is, does he have a checkbook that he can actually make a payment of costs?
I am
In other
not,
words, I was looking for a way to lower the cost because the guy showed up today. I don't know how you feel about that, Mr. Tui, but it.
Well, let me ask the officer, did he make any attempt to contact you anytime during the pendency of this case?
we only spoke on February 14.
Okay,
Yeah, so your opposition would be there was a lot of time to enter the stipulation.
absolutely.
And he didn't have the interest, he showed up but didn't have the interest to even stay to plead the case himself, so to speak?
Yeah, and I think it was maybe in this case, too little, too late. Had he done some, well, he did do some work. I mean, he mowed the lawn, that was good, but nonetheless, he didn't clean up any of the debris that was around the property, so, okay. Just know that is an option, and it's an unusual circumstance, but if somebody does show up and wants to enter a stipulation, you can kind of do that on the fly, even on a violation order, just show it as a stipulated order finding violation,
Thank you, sir.
as long as they sign it. Okay, so on the recommended order, I've removed reference to 67201A, and we're down to the trash issue. Okay, so without objection, and I'm going to accept into evidence the county's exhibits 1 through 12 in this case. I'm going to order, based upon the evidence and testimony, order compliance on or before August 30th, 2024, failing which a fine in the amount of $100 per day will accrue. And I am going to award costs in the amount of $575 to be paid to the county at the conclusion of this hearing.
Thank you, sir.
And that's that one. Okay. Next one is case number ENF 2024-020217-01. Rose Ann Barbudo, Revocable Trust is the respondent. And whenever you're ready.
My name is Tamika Bush, and I have been sworn in. I'm a co-compliance investigator for Martin County. We have entered into a stipulation of agreement. The respondent, Roseanne Barbudo, Revocable Trust, is not present. The case concerns the property at 8495 Southeast Palm Street in Hope Sound, Florida, 33455 in Martin County, Florida. This case was not generated from an anonymous complaint. And according to the official records of the property appraiser of Martin County, the property owner is Roseanne Barbudo, Revocable Trust.
Okay.
A copy of the property appraiser's record of ownership is County's Exhibit 1. On February 12, 2024, I inspected the property and left the door hanger to obtain a permit for a seawall/retaining wall that was installed without a permit. Exhibit 2 shows the door hanger. These are some building materials in Exhibit 3. Exhibit 4 shows the wall. Exhibit 5 is the same.
Okay.
Based upon the investigation, I issued a notice of violation to Roseanne Barbudo Revocable Trust on April 9th, 2024, marked as County's Exhibit 6, and in the notice, I cited the following Martin County Code violation. Sections 105.1 FBC, permits when required, incorporated by Sections 21.1, General Ordinances of Martin County. In the notice of violation, the respondent was given until May 6, 2024, to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on June 11, 2024, and is marked as County's Exhibit 7. The return receipt was not received. The property and county's administration building was posted on July 1st, 2024, and is marked as County's Exhibit 8. On July 1st, 2024, the owner was sent a proposed stipulation of agreement. The owner agreed and signed to come into compliance with the cited provisions of the Martin County Code by October 31st, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. The owner has paid the agreed administrative cost of $350, and at this time, I request that all the county's exhibits be received into evidence.
Okay, so without objection, I will accept into evidence the county's exhibits 1 through 8 in this case. Based upon that evidence and the stipulation in front of me, I find that it is appropriate for the respondent to come into compliance with the county code on or before October 31st, 2024. Failing which, fine in the amount of $100 a day will accrue. And note for the record that $350 has been paid to the county at this time. And what the stipulation reflects that, it is signed by Roseanne Barbudo and by Tamika Bush. And although Ms. Barbudo didn't put the word trustee, the property is owned by her in trust, so I'm going to go ahead and accept it.
Thank you, sir.
All right. Okay, the next one is also a stipulated case. It's case ENF 2024-03-0018, the Maria Sirocco Revocable Trust. And that's also you, Ms.
Yes, sir.
Bush. Go ahead, whenever you're ready.
My name is Tamika Bush, and I have been sworn in. I'm a co-compliance investigator for Martin County. The respondent, Maria Sirocco Revocable Trust, is not present. We have entered into a stipulation of agreement. This case concerns the property at 9004 Southeast Series Street in Hobe Sound, Florida, 33455 in Martin County, Florida. This case was not generated from an anonymous complaint, and according to the official records of the property appraiser of Martin County, the property owner is Maria Sirocco Revocable Trust. A copy of the property appraiser's record of ownership is County's Exhibit 1. On March 18, 2024, I inspected the property, and at that time I observed installation of a staircase and landing, as well as siding work with no permits. At that time, I photographed the property. The photograph accurately shows what I saw then, and it's marked as County's Exhibits 2 through 3. Exhibit 2 displays the siding work.
I'm sorry, say that again.
Exhibit 2,
Yes.
it displays the siding work that was completed here.
Okay. Siding.
And then Exhibit 3 is where they tore up, they've torn the staircase. And then that's a picture of the staircase in the back. There is a clearer photo coming up of the staircase.
Okay, so they tore an old staircase down.
And the landing, yes, sir.
Got it. Okay.
Based upon the investigation, I issued a notice of violation to Maria Sirocco Revocable Trust on March 26, 2024, marked as County's Exhibit 4. And in the notice, I cited the following Martin County Code violations. Sections 105.1 FPC permits when required, incorporated by Sections 21.1 General Ordinances of Martin County Code. In the notice of violation, the respondent was given until April 16, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved, and a notice of hearing was issued by certified mail on May 6, 2024 and marked as County's Exhibit 5. The owner was granted additional time, and an amended notice of hearing was issued by certified mail on June 12, 2024 and is marked as County's Exhibit 6. I'm sorry,
Okay.
6 is here, and that was the notice of hearing.
Yep, that's fine.
The return receipt was not received, therefore the property and administration was posted July 1st, 2024, and an affidavit of posting is marked as County's Exhibit 7. On July 16, 2024, the owner was offered a stipulation of agreement. The owner agreed and signed the agreement to come into compliance with the cited provisions of the Martin County Code by October 2024, 30th, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 for every day the violation continues thereafter. The owner has paid the agreed administrative costs of $350, and at this time, I request that all the county's exhibits be received into evidence.
Okay.
October 31st, I'm sorry.
Yeah, it
I'm not
is
sure I
October
said it.
31st. I see that on the stipulation.
Yes, sir.
Okay, so without objection, I'll accept into evidence the county's exhibits 1 through 8 in this case. Based upon that evidence and the stipulation before me, I find that it is appropriate for the respondent to come into compliance on or before October 31st, 2024, failing which a fine in the amount of $100 per day would accrue. And then note for the record that $350 in administrative costs have been paid to the county at this time. That's what the stipulation indicates. It is signed by Maria Sirocco on behalf of the Maria Sirocco Revocable Trust and Officer Bush on behalf of the county. So I'm going to find that it's appropriate to enter the agreed order in this case. And I do have one question. Is this multifamily or is that,
Single family.
it's just a second means of
Balcony.
egress, I guess, from the second story?
Sure. So,
Okay.
Thank you,
Takes
sir.
care of that one. All right, the next one is ENF 2024-040554, and it's Stephen Seefeld, trustee. And we had a lot of trust today. Whenever you're ready.
My name is Tamika Bush, and I have been sworn in. I'm a co-compliance investigator for Martin County. The respondent, Stephen Seafield Trust, is not present, In this case, we have entered into a stipulation of agreement. This case concerns the property at 19101 Southeast Crosswinds Lane in Jupiter, Florida, 33478 in Martin County, Florida. This case was not generated from an anonymous complaint. According to the official records of the property appraiser of Martin County, the property owner, Stephen Seafield Trust, is the owner. A copy of the property appraiser's record of ownership is County's Exhibit 1.
Okay.
On April 15, 2024, a notice of expired permit was sent to the owner via email by Martin County Building Department. The expired permit originating from 2016, permit number BRA 2016090060, is for an addition to an existing house permit at 19101 Southeast Crosswinds Lane in Jupiter, Florida. The notice is marked as County's Exhibit 2.
All right, I note that it's addressed to Edward Sasso of EDS Air Conditioning, at least the copy that's here. Was there also a copy sent to Mr. Seafeld, do we know?
For the permit,
Yes.
I am not sure, but I did have personal communication with him, as well as the building official and also my supervisor, Mr. Colondo. And I do email them as well, this same copy to the emails that I have on file.
owner.
So the owner was aware of it.
Okay.
He understands.
Thank you.
Yes,
Yeah, he
sir.
must have entered a stipulation.
And just for clarification, the ordinance specifies that the notice go just to the contractor on record. But it's my understanding that of late, the county has begun to add the property owner as a second addressee, even though the ordinance doesn't require it.
You know, I mean, I think that's good practice just because theoretically, a contractor could get a notice from the county and say, okay, so what? I'm not getting paid. I'm not going back on the job. I'm leaving.
I believe that's why the county began the
And-
practice.
Yeah. So better practice is to notify the owner too. Okay. But it sounds, I mean, obviously, we've got a stipulation, so. All right, go ahead, Ms. Bush. I'm sorry. I interrupted.
An area view of the property is marked as County's Exhibit 3. This shows the addition that was placed there. Unfortunately, from the roadway, you would not be able to see the addition had I taken a photo from the roadway. So this is the property, and this is the original residence
Okay.
in the hangar. Based on the investigation, I issued a notice of violation to Stephen Seafield on May 16, 2024, which is marked as County's Exhibit 4. And in the notice, I cited the following Martin County Code violations. Sections 105.1 FPC, permits when required, incorporated by Sections 21.1 General Ordinances of Martin County Code. In the notice of violation, the respondent was given until May 30th, 2024 to correct the violation and was informed of the need to contact Martin County Code Enforcement upon doing so. Compliance was not achieved and a notice of hearing was issued via certified mail on June 13th, 2024, and is marked as County's Exhibit 5. And the return receipt was not received. The property in County's administration building was posted on July 1st, 2024, and an affidavit of posting is marked as County's Exhibit 6. And on July 1st, 2024, the owner was sent a proposed stipulation of agreement. On July 2nd, the owner signed and entered into the agreement to come into compliance with the cited provisions of the Martin County Code by November 29th, 2024, and if not in compliance by then, be required to pay a fine in the amount of $100 per day every day that the violation continues thereafter. The owner has paid the agreed administrative cost of $350, and at this time, I request that all the county's exhibits be received into evidence.
Okay. All right, so without objection, I'll accept into evidence the county's exhibits 1 through 6 in this case. And I'm just curious, did you have a conversation with them or email or something that how did you know to send them a proposed stipulation?
So, this case has been going on for a while, and initially, he came into the office and met with everyone, and at that time, pretty much prematurely, we explained that if it's not into compliance, the options that they have. And when I posted the property, he was just coming back from out of town, so I met him at the property on the day that I posted it, and he indicated that he would enter into the stipulation. Unfortunately, I guess there are a few inspections that are still warranted for the permit, so the additional time was granted until November.
Okay, all right. So the stipulation requires compliance on or before November 29th, 2024, failing which a fine in the amount of $100 a day will accrue. And a note for the record that $350 in administrative costs has been paid to the county. The stipulation is signed by Stephen Seafeld, trustee, on behalf of the trust, and Ms. Bush on behalf of the county. I'm going to find that it's appropriate to enter into this agreed order, and hopefully Mr. Seafeld will get himself in compliance here. Okay. All right, so that's it for cases. We do have a set of minutes for the June 19th hearing. So I have reviewed them and approved them, and I will go ahead and execute it. Note for the record that the staff recorder, Ms. Collane, has signed, and so has Mr. Colando, code administrator for the county, so I'm going to go ahead and approve them and sign them. Oop. It's no longer sticks. All right. Anything else to come before us today?
That's it.
All right, so the next hearing is August 21st. We will see you back at that time. Thank you. We stand adjourned.
Thank you.